My name's Chris Gerlacher with Prediction News, and we've got a bunch of legal updates to go through. But first, we're coming off the week after the 2025 elections. Of course, Democrats had a good night, but one of the lingering questions that we've been seeing is why are election contracts safe? Why are political contracts okay right now? And why is all of the heat on sports? We're going to hit that question first before we get into the new cases. So, give us a like, subscribe to our YouTube channel at Prediction News, and follow us on X at Prediction News. Now, I want to bring in Dan Wallach, appellate lawyer extraordinaire, who's been tracking all of these cases, not just for us, but for the benefit of everyone. So, Dan, starting off with election contracts, why have those not been the focus of all of these state lawsuits?
Well, in some states they are. The Nevada cease and desist letter and the Nevada warning to their gaming licensees speaks to event contracts that go beyond sports, including the Academy Awards, political event contracts, Oscars, just any competitions. Most of the states, though, and most of the jurisprudence so far has been focused on the narrower issue or broader issue of sporting events, because that's what folks are caring about. That's why gaming commissions are sending cease and desist letters. They're not doing it over political event contracts, but the more important reason may have something to do with the federal court ruling from 2014 out of the District of Columbia. We have case law that has affirmatively declared that Kalshi has the right to offer congressional control event contracts based on the federal district judge's determination that the gaming category in the special rule and consequently in Rule 40.11a only applies to games. It doesn't apply to political contests or control over Congress or the presidential election. It's sports. It's entirely sports focused, according to this one federal district court opinion that was rendered in the fall of 2014. So as a matter of case law, Kalshi is covered under the CFTC CEA regime based upon the DC federal court's ruling, and that's the only federal judicial decision which has specifically addressed this topic. And as a result, that was the very first type of event contract beyond the normal stuff of interest rates and weather patterns that Kalshi ventured into, and that ultimately paved the way for Kalshi to take a much more aggressive stance and expand into sporting events. But the sporting event issue hasn't been decisively resolved by the federal courts yet. The political control event contracts have been, at least in the District of Columbia, but that's an issue that's still going to percolate in some of the later or ensuing federal decisions where Nevada is challenging that part of it, and I think New Jersey is as well. So it's not a dead issue. But based on current law, these are perfectly allowable at the current time based on the 2024 DC federal court decision.
Right. And that was 2024, not 2014, right?
Did I say 2014?
Yeah.
Okay, 2024. I've had 2014 on my mind. I guess Dodd-Frank is bringing me back in time to the 2010s, and I have that decade is top of mind. But I meant to say 2024. The ruling is barely a year old.
Yeah. So the political contracts are, for the moment, not completely safe, but certainly not the focus of the hostility from states who want to protect their state sports betting industries.
Right. Gambling commissions on the state level aren't regulating political contests. They're regulating the gambling around sporting events. So when the Nevada Gaming Control Board, when the New York State Gaming Commission, Massachusetts Gaming Commission, all these gaming commissions are regulating casino and sports wagering. They're not regulating who wins a particular election. Now, that might be a concern anyway, but by and large, the focus has been on the state regulated sports gambling market and whether Kalshi's event contracts based on the outcomes of sporting events violate state law and whether they are even permissible under federal law. And that has led to all these judicial analyses over what Congress intended with the Dodd-Frank Act. And that's the debate that is largely played out in the Nevada, New Jersey, Maryland, and Third Circuit federal courts. The debate and all the dialogue, all of the rhetoric in those arguments and in those cases, almost all of it is focused on sports gambling, not political contests.
Let's get into Nevada. There's a big hearing in that state coming up. Give us a preview of what we can expect from that one.
3 days or 4. I guess we're going to be going live with this podcast on Monday, November 10th. On Friday, November 14th at 12:30 Eastern, 9:30 a.m. Pacific. Nevada Chief Federal District Judge Andrew P. Gordon will be holding a double oral argument in the Kalshi versus Nevada case and in the Robin Hood versus Nevada case. And the crux of Friday's motion will be, will Robin Hood be successful in getting a preliminary injunction to ban the state of Nevada, at least temporarily, from enforcing its state gambling laws and state licensing laws against Robin Hood? And at the same time, Nevada wants the preliminary injunction, which Judge Gordon had issued to Kalshi all the way back in April. They want that injunction dissolved based upon the authority of the Crypto.com decision, in which Judge Gordon concluded that sporting event outcomes don't qualify for treatment as swap contracts, because the definition of a swap under the CFTC is focused mainly on the occurrence or non-occurrence of an event, and an outcome is not an event. So based on the Crypto.com decision, the Maryland federal decision from August 1st, and thirdly, Kalshi's foray or expansion into a much more aggressive form of event contracts that are based on individual player performance, the so-called prop bets that have gotten a lot of attention lately in the NBA, Major League Baseball, betting scandals, and the parlay bets that Kalshi is now offering. It's Nevada's position that the circumstances have significantly changed since May, with the advent of these parlays and prop bets changing the entire complexion of what Kalshi is now offering, as contrasted with the Super Bowl, the Masters golf tournament type of examples that were part of the earlier injunction oral argument. So that's the issue going forward on Friday morning or afternoon, depending on your time zone. And we should get a pretty good indication by the end of the oral argument which way the judge is leaning. He tipped his hat or tipped his hand in the Crypto.com case at the oral argument. I think I was one of the first people to report. I was the first person to report that Judge Gordon had determined that sporting event outcomes based on Crypto.com's self-certifications don't qualify as swaps for the reasons I just laid out. I got my hands on the transcript, within 24 hours. That was his decision on the record, and he later memorialized it in a ruling. I would expect, based on how he's conducted himself previously in both the first oral argument in the Kalshi case and in the Crypto.com oral argument, I think he's gonna let us know where pretty much where he stands on whether he's leaning or tilting towards either granting the motion to dissolve the preliminary injunction, or alternatively leaving the preliminary injunction in place. And there are good reasons to support both potential outcomes. I mean, after all, he's already determined that outcomes of sporting events aren't swaps. So there's that. But on the other hand, Milbank didn't argue the Crypto.com case. Milbank's lawyers have filed legal arguments that go a little bit beyond what Crypto.com's lawyers argued in their motion for a preliminary injunction. So just because it wasn't a successful argument for Crypto.com doesn't necessarily foreclose the possibility that Kalshi will be successful in turning the judge around yet again. So the judge did a 180, but the question ultimately is, will he do a 360 and end up back at the same place? And I think we'll find out. We'll have some general idea of which way he's going to rule by the end of the hearing on Friday. And if you want to watch the hearing, there's a mechanism for doing so in the federal court system. I shouldn't give this away, but anyone who follows me and follows you on social media knows that the federal courts in Nevada allow for members of the public to view the proceedings remotely via audio. And yours truly filed a request for remote access to the hearing. That request was granted, and I think there's still a couple of days left before the hearing. So unless you want to hear the outcome from me and Chris and wait for the Prediction News podcast on the oral argument, if you prefer not to wait, just file a motion with the Nevada federal, with the clerk's office, submit that request, and they grant all of them. So it is going to be available in real time to be listened to live, only on audio. Otherwise, you could get the lowdown from us probably by Monday the 17th, or maybe even over the weekend.
Mm-hmm. And if Nevada rules against Kalshi, will Kalshi then have to begin geofencing?
No, not immediately. They're going to file a notice of appeal. We're already 25 or 26 days into the Crypto.com decision, and Crypto.com has yet to file a notice of appeal, even though it had indicated it's going to appeal Judge Gordon's denial of the preliminary injunction motion. Now, motions for preliminary injunction are appealable whether they're granted or denied. So I think what Crypto.com is waiting for is to get as close as possible to the oral argument date with Kalshi, so that if and when the judge dissolves Kalshi's preliminary injunction, there will be two appeals that are almost simultaneously filed that could be consolidated into one overall appellate case. But the answer to your question is that the geofencing doesn't begin with the adverse ruling. It could begin if the judge had granted an injunction against Kalshi. But here, Kalshi is playing offense and has filed a motion for a preliminary injunction. So the denial of that injunction, all that means is that the state is now free to pursue civil enforcement remedies under state law to begin the process of forcing Kalshi to geofence. But we're not even going to wait for that. On the day of or the day after the ruling, Kalshi is going to file not only its notice of appeal, but an emergency motion for an injunction pending appeal, so that as long as it's pursuing its appellate rights in the Ninth Circuit and then thereafter at the U.S. Supreme Court, it's going to be asking the district court judge, the Ninth Circuit U.S. Court of Appeals, and potentially the U.S. Supreme Court to impose an injunction for the duration of the appeal to preserve the status quo and enable Kalshi to continue to argue the merits of its federal preemption argument. So it's quite possible that it could be a number of months before we find out whether an adverse ruling to Kalshi leads to Kalshi having to geofence. Now, Crypto.com has abandoned any notion of fighting this. They're appealing Judge Gordon. They will be appealing Judge Gordon's ruling, but have nonetheless declined to file a motion for a stay pending appeal, and have entered into an agreement with the state of Nevada not to offer event contracts within Nevada during the pendency of the upcoming appeal. So on the one hand, Crypto.com has agreed to either geofence or the equivalent of geofence by not offering their contracts within Nevada. Kalshi, on the other hand, is almost assuredly going to fight any efforts to geofence if they have their preliminary injunction dissolved. And I would expect there to be emergency motion practice right away before the district court in Nevada, then before the Ninth Circuit, and then ultimately before the shadow docket or emergency docket of the U.S. Supreme Court. Those emergency filings could happen in rapid fire succession. So when one court denies the emergency motion, the next court will handle it. And then if the Ninth Circuit denies it, Kalshi then goes up to the U.S. Supreme Court. How long will that process take? Not as long as the appeal, but certainly not a couple of weeks either. So worst case scenario for Kalshi is that they lose and have their preliminary injunction dissolved, and then lose 3 times in a row before the district court, the Ninth Circuit, and SCOTUS on an emergency motion for an injunction pending appeal. And to basically go 0 for 4 and get to that point, we're looking at a minimum of 2 to 3 months before there's any clarity around that.
Okay, so we're looking really at the spring for the basic set of Nevada issues right in front of us now.
Yeah, excuse me, my chair just dipped. So if I look shorter to people, my chair dipped. So let me get reorganized here.
No worries. Well, while you do, let me bring you over to Massachusetts, because Kalshi briefly had that case moved out of state court to federal court. The state was successful in remanding it back to state court. What does that mean for Kalshi?
I mean, that was effectively the victory, right? Kalshi's only pathway to success here against the states is to convince a federal court that the Commodity Exchange Act's grant of exclusive jurisdiction to the CFTC to regulate swaps displaces state gambling laws on the same subject. And while the states can regulate sports gambling occurring within their general state borders to the extent that the contracts are traded on CFTC regulated exchanges, that's only under the purview of the CFTC. Well, Kalshi lost that argument. They had to argue, Kalshi had to argue on a motion to remand that there was complete preemption, not just general preemption, but the slightly higher bar of complete preemption, which required Kalshi to demonstrate that there was a comparable or an analogous federal cause of action for the Commonwealth of Massachusetts under federal law. The judge never reached that threshold issue because Judge Richard Stearns of the U.S. District Court in Massachusetts looked at Kalshi's preemption argument and said, this is not a complete preemption argument. This is just a general, plain vanilla general preemption argument that didn't articulate any of the complete preemption principles, and viewed as a plain vanilla preemption argument. The judge found and determined in an electronic order. He didn't even write a legal opinion. There was no written opinion. It was an electronic order that just showed up on the docket. There's no PDF. You can't download it. It's only available on Pacer. And he ruled that there was no clear intent demonstrated in the CEA or the legislative history for state gambling laws to be preempted by virtue of the CFTC's exclusive jurisdiction over swaps. I guess he found equivalent or comparable to how Judge Adam Abelson ruled in Maryland and how Judge Gordon ruled in the Crypto.com case. All of those decisions analyzed the issue through the prism of congressional intent. And in all three of those instances, the judges found that the requisite clear and manifest intent under federal law was missing. And consequently, the judge remanded the case back to the Commonwealth of Massachusetts Superior Court, where the case is now set for will be set soon for a hearing on the Commonwealth's emergency motion for a preliminary injunction against Kalshi. The relief that the Commonwealth seeks is to enjoin Kalshi from offering any of its event contracts tied to sporting events within the Commonwealth of Massachusetts. That's geofencing.
Right.
The geofencing is the remedy that the Commonwealth of Massachusetts seeks in its own motion for a preliminary injunction. And this is the first time that Kalshi will be subjected to not only an offensive state government motion for preliminary injunction, but one that's pending in state court rather than federal court. So Kalshi is now operating in a perilous new venue where a state court judge is going to be analyzing whether Kalshi's event contracts tied to sporting events involve sports gambling under state law. Mm-hmm. So with the federal preemption argument basically being the only defense that Kalshi has here, with one federal court having ruled or opined negatively on that in the Massachusetts federal decision, it's highly likely that a Superior Court judge in the Commonwealth of Massachusetts is not going to deny the motion by the state on the basis that federal law preempts state law. I think that's a highly unlikely outcome. And my expectation, and let's talk about the timing, because I've spoken with the scheduling clerk for the Superior Court judge in this case. I've spoken to the clerk's office. The scheduling clerk is out until Wednesday until she comes back from her vacation, because this is how state court works. This is not the finely tuned machinery of the glossy federal judicial building. State court is an entirely different animal, and until this one scheduling clerk comes back on Wednesday, nothing will be scheduled on the Commonwealth's motion for preliminary injunction. But when she does come back, and we will have coverage live from the courthouse when she comes in from her vacation. But when she comes back, she will likely within a few days set this down for a hearing before the Superior Court judge. And I would expect that hearing to take place with the Thanksgiving holidays coming up. I think it's highly unlikely that anything will be scheduled before Thanksgiving, although it's possible, but I would look for within the next 30 days for there to be a hearing on the Commonwealth's emergency motion for a preliminary injunction. And Kalshi has yet to file its response. So there's got to be sufficient time for Kalshi to file an opposition brief, and then for the Commonwealth to get the last word on a reply brief. And that kind of window, I think, allows for 10, 15 days, and that pushes us right into the Thanksgiving holiday. So I think the week after Thanksgiving is in my view, probably the sweet spot for a hearing date.
Why haven't other states been able to bring Kalshi into state court?
Because in many state laws, the Attorney General or the state gambling commissions have to provide a cease and desist notice or advance notice. By way of example, in New York State, Section 6312 of the New York Executive Law allows the state Attorney General to sue businesses for repeat violations of state law. So applying that to the gambling context, if Kalshi repeatedly violates state law, it could be subject to suit under Section 6312, giving the Attorney General the right to bring a civil enforcement action. But the statute requires 5 days advance notice. And it precludes the element of surprise and doesn't allow or enable the state AG's office to file its own preemptive or at least initial state court lawsuit. And once you give advance notice to Kalshi, I mean, they've got their complaints already pre-drafted. So in the New York case, Kalshi received a cease and desist letter late Friday afternoon, a little bit over a week. It was about 2 weeks ago now, and Kalshi filed its federal lawsuit over the weekend.
They did remarkably fast.
Yeah, and there was a legitimate reason why Kalshi didn't want to lose the race to the courthouse, because if the state had won the race to the courthouse and filed it in New York County Supreme Court, the remedies available under state law are not really optimal for Kalshi, because the New York Attorney General is entitled, if she prevails in persuading a state court judge that Kalshi's event contracts for sporting events involve gambling in violation of New York law, the remedies are restitution, disgorgement, civil penalties at $5,000 per transaction, or at least per offense, which could be viewed as per transaction, as well as an injunction shutting down the website. And then to make matters worse, the New York Executive Law, I guess, judicial rulings that have interpreted that statute have allowed the state AG's office to obtain nationwide disgorgement for all income generated by the New York-based business from wherever located, even if the customer is located in Illinois or Hawaii. A string of New York decisions allows the AG's office to recover disgorgement from any and all revenue sources nationwide. And then on top of that, for the icing on the cake, New York is one of the few jurisdictions where the torts committed or the civil offenses committed by the gambling operator can be pursued individually from the officers, directors, and shareholders of the company under a piercing of the corporate veil theory. And there's a Marine Midland case, New York Court of Appeals decision that allows that. And the gambling case that I refer to is when New York State Attorney General Dennis Vacco sued an Antiguan offshore casino in the late 1990s for offering online casino gambling to New York-based residents, while the Antiguan casino was beyond the jurisdictional reach of the New York State courts. The judge nonetheless held that the officers, directors, and shareholders of the company were individually liable for the torts of the non-US based business. So the stakes are very, very high for Kalshi here. They want to win the races to the courthouse in any jurisdiction, but in New York, it became like a DEFCON 5 because of the 5-day waiting period, along with the consequences of losing the race to the courthouse.
Right. And why did filing early let them avoid those potential consequences in the event of a loss?
Because if Kalshi were to have lost the race to the courthouse and ended up in state court, they would have removed it to federal court like the next day. But as with its Massachusetts notice of removal, once there's a motion to remand filed in the federal court to get the case back to the New York State court, Kalshi again would have to demonstrate complete preemption which requires the showing that there's a federal cause of action available for New York State. So there's that hurdle that they weren't able to clear in the Massachusetts case. So it would behoove them to file first in federal court and articulate a general preemption argument based around field preemption, implied preemption, express preemption. The bar is somewhat lower for Kalshi when they preemptively file suit in federal court than when they remove a state court action to federal court and then have to show complete preemption. So that subtle difference between general preemption and complete preemption is basically the difference, or could be the difference, between ending up in state court or remaining in federal court.
And New York also has a bill in the assembly, introduced in the assembly, to prohibit sports event contracts as well. How do you think that's going to go?
Great segue. The bill was unnecessary and likely won't pass because in New York State, all gambling-related legislation has to initiate with the chairs of the New York State Assembly Racing, Gaming, and Wagering Commission, or on the Senate side, the New York State Gaming, Racing, and Wagering Committee, and that would be Senator Joe Adabo on the Senate side. Clyde Vanel is the lawmaker who's on the Assembly Committee for Racing and Wagering, but he's not the chairperson. So every year, Clyde Vanel files a bunch of, I wouldn't say they were vanity bills, but he files an awful lot of bills. And I wouldn't say so few of them get passed. I would say that none of them get passed. So as a practical matter, I think he's brought attention to this issue, but this is not the bill that will ultimately pass through the legislature. Yeah, obviously, if it passes and Kalshi is successful in getting a preliminary injunction against New York State, this bill, which is from New York State, would likely suffer from the same infirmities as being an intrusion upon federal exclusive jurisdiction. So if Kalshi loses its case in New York because it does not get a preliminary injunction, I guess theoretically this legislative bill, which for me, what was really important about the bill is not that it made prediction markets illegal or offering sports event contracts illegal. Let's face it, if it's gambling, there are plenty of remedies available in statutory provisions already available under existing New York law to give the New York Attorney General sufficient legal authority to sue Kalshi directly for promoting gambling in the first degree, promoting gambling in the second degree, bookmaking and pool selling, which are statutory prohibitions, and even at the New York constitutional level, there's a constitutional level prohibition against gambling. So if it's gambling, you don't really need to have a new separately enacted state statute to say that prediction markets are illegal. If Kalshi is unable to get a preliminary injunction granted in its favor, the New York Attorney General can run into state court under existing New York penal law provisions and get whatever relief is available for any violations of the state's anti-gambling laws. You don't need the Clyde Vanel bill to accomplish that objective. But I think the real reason it was filed was to increase the penalties and to give the Attorney General, Letitia James, more enforcement tools to use against sports prediction markets. And let me give you an illustration. Under the New York executive law and under the false advertising law, there's a civil penalty provision of $5,000 per violation. Vanel's bill, which was filed a couple of days ago, increases that tenfold to $50,000 and includes language requiring disgorgement of all income associated with these prediction markets times 2. So it's an increasing by tenfold the amount of the civil penalty. It allows for a double disgorgement of any prediction markets net income associated with sports prediction markets, and also carries a potential $1 million a day civil penalty. So the takeaway for me from Clyde Vanel's bill that dropped on Friday night was it gave Letitia James a heck of a lot more to throw at Kalshi in the event that Kalshi is unsuccessful in keeping the case in federal court and the Attorney General can then thereafter sue Kalshi in New York County Supreme Court. So for me, all the stuff is window dressing except for the penalties. The penalties are what are particularly relevant about this bill, not the prediction markets being banned or you can't do sports event contracts. If it's gambling without the need to create a separate statutory provision to say that sports event contracts are gambling.
He must really want to punish Kalshi if he's increasing the penalties that much. Probably Polymarket too once they launch.
Well, they're not launching anytime soon. The government is shut down. So I wonder whether that has anything to do with Polymarket's delay in entering the sports prediction market space. I mean, I don't know how you can file a self-certification, but the CFTC is powerless to do anything about it. So maybe as a result of the government shutdown, it has delayed Polymarket's entry into the space.
Mm-hmm. And the last new legal filings are coming into Ohio. We've seen a bunch of these already, but what's different or new about this set of arguments from Ohio?
Well, the Ohio lawsuit that Kalshi initiated was the first one and the only one to date in which Kalshi has raised the specter of these gaming agencies' warning letters to licensees as creating irreparable harm for Kalshi. Remember, a big centerpiece of Kalshi's irreparable harm argument in Ohio is that they were in negotiations with these unnamed, the sports betting and gaming companies. And when the Ohio Casino Control Commission issued its notice to licensees warning them of adverse licensing repercussions if they were involved in sports prediction markets, that brought a complete halt to any meaningful conversations between Kalshi and these unnamed, sports betting companies. So Kalshi's argument in Ohio is that the irreparable harm now isn't just from geofencing, but the state of Ohio's intrusion into our conversations with gambling companies has constituted this tortious interference, which is causing us irreparable harm by preventing us from entering into any deals that would allow for partnerships with the licensed sports betting companies, which have a tremendous amount of market share all over the country, particularly in Ohio. And that's an argument that hadn't been raised before in any of the prior lawsuits, and it hasn't been raised since. So this is the first Kalshi case in which the state gambling agency warnings has become an issue in the lawsuit.
That's interesting. How do you think it's going to affect Kalshi's chances of winning?
I don't think much at all, because unless you can name those companies, unless you attach correspondence, I mean, you could have a confidentiality stipulation. There are ways to keep prying eyes away from determining who these businesses are. You could have it be for the judge's eyes only. But unless you're going to show a term sheet, letter of intent, meaningfully advanced conversations with companies, I'm not going to name companies, so I don't know who they're talking to, but you're going to need something more than just one side's self-interested version of the events. And if there was a term sheet, a letter of intent, a proposal even, something beyond just Sarah Slane's self-interested affidavit. She's the corporate advisor for Kalshi. I think without there being any evidence, written evidence, documentary evidence, it's all hearsay and it's speculative. And I don't think it's sufficient, at least to meet the very high bar for immediate irreparable harm under federal law, which is what you would need to demonstrate for Kalshi to get a preliminary injunction. So I think it is it brings a different element to the case, but it's a very high bar for Kalshi to clear under governing federal standards. And what they've done so far in their motion for PI, I don't think gets them over the hump. But they don't have they will have the last word on this subject, because Ohio filed its opposition brief on Friday. Kalshi's reply brief is due on December 1st, which is a couple of weeks away. Ohio's opposition points to the fact that generalized concerns expressed by unnamed companies are inadmissible hearsay and are too speculative to give rise to irreparable harm. So I think that switches the burden or shifts the onus back onto Kalshi to come forward with meaningful objective evidence showing that some of these conversations or discussions advanced to such a meaningful stage that the regulator letters were the reason that the deals cratered.
Mm-hmm. So Kalshi could reveal, if not publicly in a public document, even just to the judge, what those partnerships could have been.
I think they need a little bit more detail than what they've provided in an affidavit from one of their internal corporate officers. I mean, Sarah Slane may have had those discussions, but unless she's attaching, proof or attaching evidence, emails, and of course, Kalshi is not in a position to do that because it would probably compromise their whatever negotiations they had with these companies. So it's a very sensitive area. But there's a way to bring this before the court under the judge's eyes only, where the court can review these communications in camera without identifying the companies publicly and then making a ruling based on his in-camera review of these hypothetical deal documents. So they're going to get one more bite at the apple on this, and unless they come forward with more meaningful documentary evidence or any documentary evidence other than an affidavit from their own employee, I think they're going to lose on that basis. But they can still, I think there's still an opportunity for Kalshi to make a more compelling case that this interference was real. Other important aspect of Ohio is that Ohio, with its filing, becomes the second state after Massachusetts to articulate the legal arguments post Crypto.com ruling. So
it's true.
Yeah. So this is not same old, just cut and paste what Maryland argued. We now have the benefit of the Crypto.com decision, Kalshi's foray or aggressive expansion into props and parlays. And this is the second state, only the second state to have utilized outside counsel, right? Nevada has Mayor Brown and principally Nicole Saharsky, the U.S. Supreme Court superstar from Mayor Brown, being lead counsel for Ohio. For Nevada, Ohio is the only other state that has engaged outside counsel, and this brief that was filed on Friday night reflects what I consider a best-in-class type of work product. If you don't mind, I'd like to read not the whole brief, but the opening statement, which sets the stage.
All right, let's hear it.
Because no one else is going to have this. This case is striking, not just for its subject matter, but also for the audacity of the relief Kalshi seeks. Kalshi asks this court to accept the breathtaking proposition that when Congress adopted the Dodd-Frank reforms in 2010 to address the causes of the 2008 financial crisis, Congress silently, one, transformed federal gambling law by legalizing sports gaming nationwide for the first time, two, stripped every state of its police power to prohibit or regulate sports gaming, three, required that all sports gaming in the country take place on federally designated commodities exchanges, and four, made the CFTC the nation's exclusive regulator of sports gaming. Well, that might go a little far in some of those assertions, but all of that happened, according to Kalshi, simply because Congress added swaps to the CFTC's exclusive jurisdiction under the Commodity Exchange Act as part of Dodd-Frank. One more sentence. Remarkably, Kalshi suggests that no one noticed the sea change for nearly 15 years. Not the Supreme Court, which discerned a coherent federal policy embodied in federal gambling statutes that respect the policy choices of the people of each state on the controversial issue of gambling, and did not even identify the Commodity Exchange Act as a federal statute affecting sports gaming. And I'll stop at that point. But the opening statement, the preliminary statement made by Ohio's outside counsel, I think is the best iteration, the best opening that I've seen in any of the federal court briefs. So I think Ohio has come in very strong here and filed what I consider to be a really top level opposition brief. And does it mean that they're going to win? No, but I think what they've done on a quality level is way beyond what New Jersey did in opposition to Kalshi's preliminary injunction request, and much stronger than the state AG's office in Nevada originally put forward back in April. I think as these arguments or as these cases begin to attract more lawyers, and there's consequently a much more expanded and sophisticated development of the legal arguments around these issues. And I think as the states are getting more refined at this and are really focusing on the issue of congressional intent, I think that bodes well for the states ultimately in some of these cases. Now, does it mean that Kalshi is going to lose them? No, not necessarily. Kalshi did well at the Third Circuit U.S. Court of Appeals. They won in New Jersey. They still have an injunction in place in Nevada. So I wouldn't say it's decisively one-sided, but I think the recent trend, Maryland, Crypto.com, and Massachusetts are starting to kind of point in the state's favor. And Ohio is the first brief. The Ohio Attorney General brief is the first one to effectively use the Murphy versus NCAA case to highlight.
That was the sports betting legalization case originally in 2018.
Sports betting legalization case. And I think it would have been quite a surprise to SCOTUS and quite a surprise to the sports leagues and to the Department of Justice litigating that case to have learned that there was a federal regulatory scheme already in place for sports gambling back in 2017 and 2018 through the Dodd-Frank amendments back in 2010. Of course, nobody raised that. The federal government didn't raise it. The leagues didn't raise it. No amici curiae raised it. So when you take a closer look at the language in Murphy versus NCAA about these federal statutes, naming the Wire Act, the Illegal Gambling Business Act, the Travel Act, and the Wagering Paraphernalia Act, the Murphy Court identified 4 federal statutes as embodying a coherent federal policy of respecting state policy choices on the controversial subject of gambling. The High Court made that declaration in a case about sports gambling. So that is a hill that Kalshi may end up dying on if and when this gets to the Supreme Court. That is a very powerful statement that SCOTUS made in Murphy versus NCAA. So even when you look beyond all the congressional intent indicators, I think Kalshi is going to have to grapple with the Supreme Court's own analysis of how federal law treats the subject of sports gambling.
There's just so much intrigue that the courts are going to have to unwind through these cases, but we've covered so much ground. Remind us all where we can find you on social media.
Oh, geez, it's really hard, but Wallach Legal on X, which is the only handle I've used for the last 10 years. By the way, a little side note, I got hacked. My Wallach Legal account got hacked a year ago when I had 35,000 followers. So I had to wait a day. I reclaimed the name and had to build everything back up from zero. So if you see 2,500 followers, don't get alarmed, folks. I had to build that all back up in year one. That's where you can find me on X. Where you can find me on LinkedIn is Daniel Wallach, and the name of my law firm is Wallach Legal. So if you search for me on LinkedIn through the name of my firm and my name, you'll find me. But the first place where I post anything, the first place where I break news or discuss anything related to the prediction markets is always going to be on X.
Well, there's one man who's easy to find. It is Daniel Wallach. Give us a like, subscribe to our YouTube channel at Prediction News, and follow us on X at Prediction News. Dan, thanks again so much for stopping by and explaining this all for us.
Yeah, it was really nice visiting with you today, Chris. You've done a fantastic job with Prediction News, and both the site and the podcast, and I'm honored to be able to be part of your podcast and looking forward to doing more of these. And I think there's some job security here with 3 years of litigation remaining. So I'm looking forward to popping in again and joining you and others on the podcast and maybe having some other special guests from time to time.